Hello, I'm Robin Henry. I'm the head of dispute resolution at Collier Bristow. I'm here with my colleague Gavin Kramer, and we are doing a podcast on the BHS wrongful trading and trading misfeasance case against directors of that company. Now, we've already done the first part of our podcast looking at wrongful trading, the wrongful trading claims against the directors of the company. And so we're coming back for a second part where we're going to specifically look at the trading misfeasance claims, which are set out in the judgment against the directors. Now, much has been made of this claim of trading misfeasance, which is the first time that this has been successfully brought against directors of an insolvent company. And although it is a novel claim and hasn't been successfully brought in the past, I think it's important to mention that this is not a claim which is derived out of thin air. That's not how the courts work, thankfully. And it does have a statutory basis. So I'm just going to set out for you what the statutory basis of this trading misfeasance claim is. And where it comes from is section 212 of the Insolvency Act, and it provides a procedure for the recovery of property or compensation by a liquidator against an officer of the company. And it provides that if in the course of a winding up of a company, it appears that a director has misapplied or retained or become accountable for any money or other property of the company, or has been guilty of any misfeasance or breach of any fiduciary or other duty in relation to the company, then the court may, if there is an application by the liquidator, to compel the director to contribute such sum to the company's assets by way of compensation as the court thinks just. Now, in this particular case, what we're talking about or looking at is a breach of fiduciary duty by the directors concerned. And those directors' duties were originally derived from common law, but they've been now codified into statute, and they are to be found in the Companies Act 2006. And in particular, in relation to the BHS judgment, we're looking at section 172 of the Companies Act, in particular, which relates to a director's duty to promote the success of the company. So what section 172 says is that a director must act in the way he considers would be most likely to promote the success of the company for the benefit of its members as a whole. So in normal circumstances, a director needs to think about shareholders' interests. However, section 172 also preserves a common law requirement for directors to consider the interests of creditors in certain circumstances. And I think this is why this has come up now in the BHS judgment, is because a couple of years ago there was a case called Sequana, which looked at this common law requirement for directors to consider the interests of creditors. And the Supreme Court said or confirmed that in looking at section 172, the directors in certain circumstances had to have regard to the interests of creditors. And that's referred to as the modified director's duty under section 172. So what did the Sequana case decide? Well, it confirmed that in relation to the duty to promote the success of the company, directors have a duty to consider the interests of creditors in the following circumstances. Number one, where the company is insolvent or bordering on insolvency. Number two, where an insolvent liquidation or administration is probable, or where a transaction is being entered into which would place the company in either of those first two situations. Now, you compare that with the wrongful trading test, which is where directors have to consider that there is no reasonable prospect of the company avoiding liquidation. So effectively, wrongful trading looks at the position where liquidation looks inevitable, whereas these directors' duties, or director's duty, comes into play at an earlier stage, usually, where an insolvent liquidation is probable. So it's more than likely than not. And the interests of the creditors at that point need to be taken into account by the directors, as well as the interests of shareholders. And what the court said is that there is a sliding scale of importance which is going to be given to the creditors' interests the more precarious the company's financial position becomes. So the more likely it is that there's going to be a liquidation, the more the directors have to consider the interests of creditors. And once liquidation becomes inevitable, then the creditors' interests will become paramount. So what happened in BHS? Was it probable or inevitable that liquidation was going to happen at the point when the director's duty came into play? And at what point on the sliding scale was it that their director's duties became engaged? Now, in Sequana, the Supreme Court recognised the existence of Section 214, wrongful trading, and said that that put a constraint on how far they could extend a common law duty of directors' duties, because we already had Section 214, we already had wrongful trading on the statute book. They recognised that it was only in rare circumstances that such questions would arise. In many cases, what the court said was, when a company is bordering on insolvency, an obligation to consider the interests of a company's creditors and balance them against the interests of the shareholders would involve the directors in making a commercial judgment about the benefits and risks of the transaction, which would not necessarily be criticised. But they mentioned a specific set of circumstances in which they thought the director's duty would apply whether or not wrongful trading would also apply. And so they gave, by way of an example, this example. So a company's been unsuccessful and the capital of the shareholders has been lost through balance sheet insolvency. So the assets of the company are less than its liabilities, and as a result, the shareholders will get nothing if the company goes into insolvency. And the directors know that a formal insolvency process is more likely than not. And there is a prospect of avoiding that insolvency, the formal insolvency, only if the company were to undertake a particularly risky transaction. But that is not going to affect the shareholders because they have no interest anymore in the company's future, but it may well have a very damaging effect on the creditors if it goes wrong. And what the court described this as being a last roll of the dice, because the likely alternative would be a formal insolvency from which the creditors would receive very little. And what the Supreme Court called this was an insolvency deepening activity. So effectively you are, by your actions, you're taking a step which might just rescue the company or improve the situation of the company, but is actually more likely to have a very damaging effect on the creditors and is to make things much worse for them. So what the Supreme Court was saying they were trying to do was not replace wrongful trading, but deal with a situation which they didn't think wrongful trading dealt with, which was a situation where it wasn't inevitable that the company was going to go into liquidation, but that it was a situation where the directors thought they could avoid liquidation, but only by taking very risky action, which could have the effect of affecting creditors, and doing so without the creditors' consent. The creditors would have no say in the matter. So, Gavin, perhaps we can look at the trading misfeasance claim in the BHS case, and how was that formulated, and what was the court's finding?
The Liquidators Council took a very similar approach to the way that they pleaded the misfeasance trading claim in a similar way to the manner in which they pleaded the wrongful trading claim, by selecting a series of dates at which they said in the alternative the respondents, the directors defending the claim, had they discharged their duties properly, would have concluded that the companies could not continue trading. So just as in the wrongful trading claim, they identified 6 dates in the alternative, which judge termed the knowledge dates on which the knowledge condition arose for the wrongful trading claim. In the case of the misfeasance trading or trading misfeasance claim, they identified the 6 same dates, but these were termed the cessation dates. And the question for the judge to decide was whether on any of those dates were the directors in breach of their duties as modified because of the company's insolvency, applying the Sequana test, the modified Sequana duty, as I think he terms it in the judgment, their duty to take account of the interests of creditors as much as the interests of shareholders, whether on any of those 6 alternative cessation dates, the directors were under a duty to cause the company to cease trading and then proceed either into administration or voluntary liquidation, because to continue trading would cause loss to the creditors. And the judge found that by 17th of June, that modified duty, the modified test under Sequana, the duty to consider the interests of creditors as much as, or to a greater extent than the interests of the company's shareholders, had arisen. And what I think is particularly interesting is that the cessation date, i.e. the date on which a liability for misfeasance trading arose, in the judge's view, is 2 to 3 months earlier than the knowledge date that he found applied in the case of wrongful trading. So the knowledge date for the wrongful trading claim was the 8th of September 2015, and only on that date did the directors become liable for wrongful trading. But their liability for misfeasance trading, the judge found, had arisen prior to that on the 17th of June 2015. So this is a very interesting judgment, because it means that even though the liquidators were unsuccessful in relation to the first 5 knowledge dates that they put forward in their pleaded case, and only were successful in relation to the very final date, in terms of misfeasance trading, the judge pushed back the adverse finding against the directors to a significantly earlier date, the 17th of June 2015.
And that has the effect, and we're still waiting the judge's determination as to the exact amount of the quantum of losses that would apply with having made that finding of trading misfeasance. But it's expected or indicated to be a much higher amount than for the wrongful trading claim.
I would agree, yes. We're waiting to find out how the judge is going to approach the quantification of the loss caused by the misfeasance trading, and that's a matter for a further hearing, which will be reported in due course. But yes, it seems likely that because the net deficiency will have increased by a greater amount from the earlier date of 17th June than from the knowledge date for the wrongful trading claim of 8th September 2015, that the directors may well be held to be liable for a greater amount under the misfeasance trading claim, than under the wrongful trading claim.
So I think what a lot of people would be interested to know is whether or not this introduces a situation or a potential claim against directors, which is likely to cause directors of companies concern in the future. Because until now, as lawyers, we've been advising directors as to their potential liability under wrongful trading, and it's a very specific situation that they have to consider, and a date and the amount of knowledge that they have to consider at a particular point. Now, we may well have to advise directors about a different date and a different consideration, and it may be an earlier date, or as it has been in this case, as to what they need to consider may arise in relation to or provide for a new potential claim against them if the company gets into liquidation.
I agree. I think it greatly increases the potential exposure of directors to claims in the event of their company going into liquidation. And one's initial impression is that a misfeasance trading claim may be an easier claim to prove than a wrongful trading claim, because the focus shifts to the question of whether the duty to creditors has been triggered, which is not part of the wrongful trading claim. And as the judge says in his judgment, if the members of the board had considered their duty to creditors from 17th June 2015 onwards, then in my judgment, they ought to have concluded that the interest of the group's existing creditors were paramount, or at the very least that those interests should carry more weight than the interests of the company's sole shareholder, and should therefore at that point have taken appropriate steps to place the company into a formal insolvency.
I agree. It introduces a new level of concern and potential uncertainty, but I think there's another way of looking at it, which suggests that in most situations, this type of claim of trading misfeasance would not arise. Let's take an example of a situation where you've got a company which is in financial difficulties. The directors recognise that insolvent liquidation is probable. It's not inevitable, but it's probable. And they are therefore their directors' duties, this modified directors' duty of taking into account creditors' interests, is triggered. And the directors consider, their options, and they might consider a risky transaction. And if they succeed in that transaction, then in normal circumstances, that would result in the rescue of the company, and the shareholders as well as the creditors would win. And so I think in that situation, the directors have to consider the interests of both the shareholders and creditors. And the more precarious the financial position of the company becomes, the more on this sliding scale they have to consider the interests of creditors until they reach, and I think this is the kind of a theory, until they reach a point at which liquidation is inevitable, at which point that's the same point as Section 214 of the wrongful trading situation.
So you see the two claims as likely to overlap in time, and that this instance where the judge found that the misfeasance trading liability arose at an earlier point in time is less likely to occur in most cases of liquidation.
I think there is a sort of, if there is a sort of scale, as this sliding scale, which may lead from the trading misfeasance into wrongful trading. However, in this particular case, I think the difference was that the judge decided that the shareholders had no interest in the company in June 2015, and that because they had never really invested much, if any, capital into the business in the first place. In fact, they had extracted more money out of the company in the months that they'd been in charge than they had invested into it. And I think that was perhaps a critical point, that in the words, I think in the judgment somewhere, they had no skin in the game.
Yes.
They were not going to be affected one way or another as to what they did or how the company did. So the director's responsibility was purely to look at the creditors' interests. And as the judge said, in June 2015, the interests of the creditors were paramount,
Yes.
which meant that they had to look at it in terms of, should we go ahead of this? Is it in the interests of only the creditors? And so I think it may be that this is an unusual situation in that most companies are not run as badly as this one, and are not run,
Yes, and as you point out, the sole shareholder of the group, Retail Acquisitions Limited, had been set up solely for the purpose of purchasing the group from the previous owner for £1.
Yes.
And as you say, they themselves invested nothing in the company and sought to finance it either by selling off assets or raising money on very unfavourable and non-commercial terms from third-party lenders.
So I think, and certainly this was the situation that the Supreme Court was envisaging, I think, in their view of what was an insolvency deepening activity, as they termed it, as very much egregious circumstances where the directors are really acting very much against the interests of creditors. So I don't think that we're going to see a flurry of successful trading misfeasance claims, which are, as in this one, determined at a date prior to wrongful trading cases. But we are still in a situation where we need to advise our clients as to what their potential liabilities are. We're going to need to explain not only the wrongful trading claims, but also these trading misfeasance claims, and whether how likely it is that they may be fall foul of them.
Yes, and whether it becomes a common practice for future wrongful trading claims brought by liquidators for the claimant, the applicant, to plead misfeasant trading in the alternative, in order to increase the possibility of a successful judgment against the directors under a different test.
I'm sure we will see liquidators certainly making those claims of trading misfeasance, and we may get some developing case law as a result, as those claims are tested. It's certainly going to be very interesting.
Indeed.
So that's the end of our podcast on this particular issue. But if you have any questions for either me, Robin Henry, or Gavin Kramer, please do get in touch with us at collierbristow.com.